Hello everybody. So this is second video in series of our discussion on the Panchayati Raj. In the first video, if you remember, we had discussed the evolution of Panchayati Raj institution from ancient time. Then we discussed the position of these Panchayati Raj institution in British time. We had jumped. We did not discuss what happened into the medieval times. We directly jumped to the British time, and thereafter various committees and commissions recommendation during the post-independent India. So there we had discussed the Voluntary Mehta committee's recommendation, Ashok Mehta committee's recommendation, L.M. Singhvi, Thangan committees, then you had this Gadgil committee. So all the committees recommendation we discussed in the first video. During the ancient time, we discussed that what were the terminologies which indicate the presence of these village council. Perhaps they may not be having these kind of elaborate Panchayati Raj institution that we do have today, but there were presence, the terminologies that you would be reading in the ancient India. So those Gopa, Gramini, right? Rather in the Chola administration, Cholas were rather famous for their village council, their qualification, disqualification. So they had this elaborate norm for these village council, right? So all those aspects has already been discussed in the first video. So let us see what is going to be scope of the second video. So as I already told you that even post independence India, you had various committees. So 73rd constitutional amendment that we do have today, that is nothing but a premise on the recommendation on the various report or the recommendation of various committees that were established by various governments. So you had this Balwant Mehta committee in 1957, then Ashok Mehta committee had been established by Janta government, then you had this L.M. Singhvi committee, then Thangan committee, then you have Hanumantarao committee, then finally you have this Gadgil committee in 1988. Then you had the 64th and 65th constitutional amendment, unsuccessful attempt by Rajiv Gandhi government in 1989 to have this Panchayati Raj institution, giving them constitutional status. But as I already told you that was an unsuccessful attempt by Rajiv Gandhi government. That was passed, that bill 64th and 65th constitutional amendment bill that sought to give constitutional status to Panchayati Raj institution in 1989 itself. That bill was passed on the bank of majority that Rajiv Gandhi government enjoyed into the Lok Sabha, but that could not be passed. The might of combined majority of the opposition, because opposition parties or the regional parties that had presence in Rajya Sabha, they felt threatened by certain ambitious provision that these Panchayati Raj institutions were given or sought to be given in that constitutional amendment bill. Finally, you had this P.V. Narasimha Rao government in 1992 that finally led to the passage of this Panchayati Raj institutions, local self-government. So you had this 73rd and 74th constitutional amendment. 73rd constitutional amendment deals with Panchayati Raj institution, that is in rural areas, and 74th constitutional amendment deals with urban local bodies, that is in metropolitan, means local self-government in metropolitan cities, right? So 74th constitutional amendment we'll discuss when we'll get into that chapter. Here the scope of this chapter is 73rd constitutional amendment. So let us see. So this was all about what we discussed in the first video. So let us see what we are going to discuss in the second video. So the scope of second video, if I discuss, so in this video we'll discuss various structures and provisions of 73rd constitutional amendment. So 73rd constitutional amendment is primarily about these two things, structures that it is going to create. So three-tier structure that we had discussed in the last part of the first video, if you could remember. I'll give you a glance of those structures in this video as well, or rather we'll discuss the structures or the functions of those structure elaborately in this video as well, and then we'll discuss the provision. So provision will divide into compulsory and voluntary provision, and those things we'll discuss. Then we will discuss article 243A to article 243O, right? It is these articles that discusses various composition, various functions or various other provisions about local self-government in rural areas, and then there will be 4 MCQ that will be waiting for you to be attempted, right? So as has been our tradition that we do have few MCQs for you guys as well. So let us discuss, let us start from these structures and provision. So this is the actually slide from the previous video, if you could remember. So we had discussed there that this was 73rd constitutional amendment. So what constitutional changes that 73rd constitutional amendment brought to our constitution? So first of all, that it added a new part, that is part 9 to the constitution. This I am talking about 73rd constitutional amendment. So it is going to add, or it added part 9 to the Indian Constitution, and then it introduced certain articles starting from article 243A to article 243O, right? Then it added 11th schedule to Indian Constitution, right? Initially, at the time of operationalization of Indian Constitution, we had this 395 article and 8th schedule, right? 9th schedule had been added immediately after operationalization of Constitution, right? That we already have discussed in 1951 itself, and then you had this 10th schedule that was added at the time when Sikkim was being introduced. 10th schedule that we know today, that deals with anti-defection, but at the time when 10th schedule had been added, it was not dealing with the anti-defection, it was actually dealing with this article 2B, that was dealing with the associate state status that had been provided to the Sikkim. Sikkim right now is a full-fledged state, is a part of Indian state, right? But that was not so before 1975. In 1975, it was through 36th constitutional amendment that Sikkim was made full-fledged state, but it was actually associate state, right? So this associate status has been provided because there was no provision at the time Indian Constitution had been designed. There was no provision for an associate state into the Indian Constitution, and that's why there was new schedule that had been added which talked about associate state, right? It was 10th schedule that was dealing with the associate. So this is not related to this chapter, but just because it spontaneously came into my mind, so I thought of discussing it. So you had this introduction, so you had this initially 8th schedule, right? 9th schedule 1951 and 10th schedule in 1974, I guess. 11th and 12th schedule had been, so 11th and 10th schedule is a matter of concern for this chapter. So 11th schedule had been added by 73rd constitutional amendment in 1992, and then 74th constitutional amendment at the same time added this 12th schedule. So right now what we do have is 12th schedule in Indian Constitution. So this was about 73rd constitutional amendment. Similarly, 74th constitutional amendment also added a sub part, that is part 9A to the Indian Constitution, article 253P to article 253 did I say? So article 243P to article 243Z G. So that was about, and then schedule 12 it added. So I hope you will have clarity. This is actually a revision. Now we are entering into discuss the structure and provisions of 73rd constitutional amendment. So 73rd constitutional amendment is all about the structure we already have discussed and the provisions, right? So happens with every act. Every act does have certain provision that, okay, what is the objective of this particular act. Now this objective of all these this act, 73rd constitutional amendment, has been divided into two categories. There are certain compulsory objective and there are certain voluntary. What is the meaning of this compulsory objective and voluntary objective? So let us try to understand. See, after passage of 73rd constitutional amendment 1992, it was expected from the states as well that they'll pass their own Panchayati Raj institution act, right? See, prior to this it was not that prior to 1992 state did not have any Panchayati Raj institution. Prior to 1992 as well, there were many states which did have their own Panchayati Raj institution, right, based on their state acts. Now what this 73rd constitutional amendment is going to do is that it is going to ask various states that, hey, tweak your Panchayati Raj institutions act to insert these kind of structures, so bring uniformity in the structure across the state. So earlier certain state did have these two layered structure, right? Few state had this 3 layered structure, few state may have 4 layered. So what this act did was that it asked all the state to tweak their own Panchayati Raj institution act and to bring uniformity and to all the state except the state which has population of less than 20 lakh, right? Except those states, right, all the states were asked that bring uniformity into the structure, have this 3-tiered or 3-layered structure. So one change. A second change that this act sought to do is that it asked that whatever provision that we are advising, right, they categorize their provisions of this act had been categorized into two categories. One was compulsory provision. So into the PRIs, Panchayati Raj Institution Act, that state did have, they were asked again to amend their Panchayati Raj Institutional Act to accommodate these provisions, right? But whatever provision, suppose there were 15 provision of this act, so those 15 provision of 1992 73rd Constitutional Amendment Act were divided into compulsory and voluntary provisions. So compulsory provision state had to introduce in their respective Panchayati Raj Institution Act. As far as voluntary provision is concerned, so voluntary provision was incumbent on the state whether they wanted to bring those changes, whether they wanted to introduce those provisions of the act which were voluntary or not. And in the voluntary section, when we'll see, there is something called 11th Constitution. Just a moment. There is something called this 11th schedule. In 11th schedule, there are certain items. How many items? So there are 29 items that lie into the 11th schedule, and these 29, see, until this 1992 constitutional amendment, 73rd constitutional amendment, until 1992, state was looking into all the affairs, whether it be it policy matter, whether it be it development matter, so all kind of matter, all kind of subjects, right? You have this schedule 2, list 2 into the schedule 7, so whatever subject that has been mentioned into this list 2, all is being taken care by the state. Now you have the 73rd constitutional amendment which is creating a third layer into the governance. You had this union, you had this state, now you have these PRIs as well, Panchayati Raj Institution or urban local bodies as well. So until now, state was taking care of all the functions, union was taking care, then state was taking care, but then you have this addition of third layer of governance. So you will have to transfer some kind of function to these bodies as well, otherwise there is no point of creation of this new body, right? So what state was asked to do is that whatever development function or whatever, be it in health, be it in education, be it in any sector, right? So whatever function that state was performing until 1992, states were asked that, hey states, few functions that these PRIs can perform, right, transfer those functions to these PRIs, right? Then only there is point of creation of this third layer of governance. Otherwise, if you create these structure and do not give them function, what is the point of creation, right? So there are actually 29 items that has been put up in 11th schedule, right? I'll let you know, although 11th schedule is not part of discussion of this debate, right, but this video, but I'll let you know. So there are items like sanitation, there is item like water conservation, there is item like land revenue, there is item like land improvement, there is item like libraries, right? So all these things can be taken care by Panchayati Raj institution, but there were some strong recommendation into the 11th schedule as well. 11th schedule sought to transfer these health functions to these PRIs as well. Now matters of health, it deals with appointment of doctors, it deals with appointment of ASHA workers, it deals with creation of infrastructure, right? But when you transfer these kind of appointment of doctors, when you deal with when you transfer these function of appointment of ASHA worker, when you transfer these functions of infrastructure creation from the state to the PRI, all of a sudden it is not possible that this PRI, what is this PRI? This PRI is nothing but your village council, village panchayat, then you have this intermediate level panchayat, and on the top you have this district council. Now all of a sudden these three layered institution may not be capable to understand the requirement that what kind of doctors should be appointed, right? They may not be financially equipped to deal with this infrastructure creation, they may not have that level of money, they may not have that level of expertise first of all, राइट, टू अंडरस्टैंड कि भाई इंफ्रास्ट्रक्चर के लिए क्या क्या कैसे प्लानिंग की जाती है, किस तरह से हमें इंजीनियर्स को हायर करना है, किस लेवल के इंजीनियर से आर्किटेक्ट को हायर करना है. सो दे वर नॉट कैपेसिटेटेड, राइट. यू पुट अप, यू क्रिएटेड, मीन्स with the creation of this 73rd constitutional amendment, right, you came up with 11th schedule, very ambitious 11th schedule, fine enough, good enough. You put up 29 items in that as well, no issues, right. But out of these 29 items, there were certain items which were very ambitious. When you are transferring this health like subject, right, you will have to see whether Panchayati Raj institution in 1992 of the various states were capable enough to deal with these kind of items or not, right. So states were given autonomy that there are certain provisions of this act, right, that you will have to have. Provisions like having this Gram Sabha, provisions like election, provisions like reservation for whom, reservation for SC and ST community. So these kind of, we'll discuss that what are the compulsory provision and what is this voluntary provision. So these kind of provisions state needed to have in their Panchayati Raj institution, those were compulsory, right. But there are certain provisions that were made voluntary, that if you do not want to have it, right, into your Panchayati Raj institutions act, no issues, right, you can have it on a later occasion. Why this voluntary provision were given to the state, I hope by now you would have understood, right. So now we are moving to the next slide. So first we'll discuss the structures that this 73rd constitutional amendment has created, and then we'll discuss finally that provisions of this act. So let us discuss the structures that this 73rd constitutional amendment has created. So 73rd constitutional amendment sought to create these three-tiered structure, these three-layered structure. So at the top you had this Jila Parishad, then at the intermediate, so these are nothing, these three layered structures are nothing, these are commonly called panchayats. Panchayats at the district level, at the three level, panchayat at the district level, panchayat at the intermediate level, panchayats at the village level. However, okay, means structures have been created, the three layered, and this was made this was made part of your compulsory provision, right. Means state needed to have, all the state needed to accept that 20 lakh. So whichever state which did have this less than, sorry, pen is not working. So whichever state did have this less than 20 lakh of population, they were not required to institute these three level or three layered structure, except those 20 lakh limitation, right. All the other state which had this population of above 20 lakh, they were expected to for the creation of these three layered structure. But the autonomy that was given to the state, that whatever names that you want to have. So in Hindi heartland, this district level panchayat, all these three, again I am repeating that all these three structures are called commonly panchayats. The only thing is the naming of these three layers may change from state to state. So that autonomy state does have. So in Hindi heartlands, this district council, in English means northeastern states, it can be called district council. In the Hindi heartland, it can be called Jila Parishad. In the southern state, right, they can have their own regional language, right. So it can be district panchayat, it can be district council, it can be anything, right. Panchayat Samiti, some states can refer it as Block Samiti, then some states can refer it as Taluka Samiti. So my point is that the naming can vary from state to state. Some can call it Gram Panchayat, some can call it this village council, right. So it can be called village council. So that autonomy was given to various states, that whatever naming that you want to have, so that liberty was given to various states, that naming they whatever naming that they want, the only thing that they wanted to have is, or they the 73rd constitutional amendment mandatorily wanted to have is creation of these three layered structure, except that whatever naming that they wanted to have, a state, that autonomy, that liberty was given to a state. And the second pointer that I want to raise is the difference between Gram Panchayat and this Gram Sabha. So I have often seen there is something called Gram Sabha, right, although I have already clarified that what is this Gram Sabha and what is this Gram Panchayat, but let us have a discussion on this part as well, because I have often seen many aspirants being confused into Gram Panchayat and Gram Sabha. To the Gram Panchayat they keep referring that it is Gram Sabha, and Gram Sabha they keep referring that it is Gram Panchayat. So let me tell you, this Gram Sabha and Gram Panchayat are two different entities. What is this Gram Sabha? So Gram Sabha is nothing but it is combination of all the grown up people or all the people in the village above 18 years of age who does have voter ID card, right. So all the eligible voter in a village will form part of Gram Sabha, and this Gram Sabha is going to be a permanent body, while this Gram Panchayat is an elected body, this is, mind you, this is not an elected body, but this is an elected body. So Gram Panchayat, for the purposes of election, will be divided into multiple wards. So depending on the size of that panchayat, or depending on the size of village, so suppose there are in a particular village where panchayat has been constituted, the population of that village is 10,000. So maybe that the state may decide to divide 10,000 is the population, right? So it can be divided, say 25 wards it has been divided into. So from each ward, right, there will be election, and people elected will enter into this Gram Panchayat, right, and they will finally get into choosing this their chairperson. So chairperson, and this chairperson will be elected amongst their own members, or there may be chances that there are few states that have passed that chairman as well will be directly elected. We'll discuss which are all states, so we'll discuss on that point. So my point was that this Gram Panchayat is an elected body. There are members from these wards, and ward councillors form part of Gram Panchayat, and while this Gram Sabha is a collection of members of that village who are eligible voters. So I hope the difference between Gram Panchayat and Gram Sabha you will have clarity on, right? So this was about this 3-layered structure. Let us see all these things in textual format. So as I was saying, that this Jilla Parishad can be called by different names: district council, Jilla Panchayat, district Panchayat, whatever they want to say, means it will depend on or vary from state to state. Similarly, this Panchayat Samiti can be called block Panchayat or Taluka Panchayat or Taluka Samiti. Similarly, you have this Gram Panchayat, which can also be referred as village council. So it can vary from state to state, right? What are the other points regarding these structures? So other points are that after passage of this act, the institution, these 3-layer institution, has become justiciable. What is the meaning of justiciable? So the meaning of justiciable is that if any state does not implement this 3-tiered structure, and if the population of that state is above this 20 lakh, in that case the citizen of, or the any voter of that particular state can drag that state into courts. That is the meaning of justiciable, because the states now need to have this 3-tiered structure. 2 years ago, rather from 2015 itself, there was now the status of J&K, Jammu and Kashmir, has been changed. Right now it is a UT, but as far as Panchayati Raj 73rd constitutional amendment did not have applicability as such into Jammu and Kashmir, right? It was applicable in Jammu and Kashmir, but with certain modification. Rather, they did have their own constitution, and as per their own constitution, they had this Panchayati Raj, their own act, right? But the kind of autonomy that the 73rd constitutional amendment had offered to various states, that kind of autonomy J&K constitution had not offered to their village panchayat, their block panchayat. So since 2015 itself, there was wide amount of protest to amend their Panchayati Raj Institutional Act to have the kind of provision that this 73rd constitutional amendment offers, right? But because under Article 370 you had this protection that had been provided to J&K, right? So nothing could be done by the center. Now this thing has been changed, right? So my only point was that from the justiciable angle, so if the population of any state is 20 lakh, right, and if they have not implemented this 3-tiered structure that we had seen, right, that is hiding behind this text, right, so the voter of that particular state can drag that state into the court, right? Instead of citizen, you have this voter, right? So that was the first point. The second point, however, in functional area, a degree of autonomy has been extended to the state. We'll discuss that when we'll discuss the provisions of this act. With the passage of this act, 3-tier structure has become mandatory for all state except those states which has been given some kind of concession. So we'll discuss the 5th schedule area, we'll discuss state like Mizoram, we'll discuss state like Nagaland, as I discussed these states like J&K, which earlier, prior to this removal of this Article 370, this J&K, Jammu and Kashmir, had also not implemented this 73rd constitutional amendment. So post passage of this 73rd constitutional amendment, this 3-tiered structure has become mandatory for all the states except the state that I just took the example of. So I hope you will have clarity on this point as well. The next point, Gram Panchayat should not be equated with Gram Sabha. That point we already have discussed, that what is the difference between Gram Panchayat and Gram Sabha. I hope again the discussion is not necessary, both are separate bodies. So this was all about the structures that has been created by 73rd constitutional amendment. On the next slide onwards we will discuss the provisions. Okay, there is one more. So this is the 3-tiered structure that has been created by 73rd constitutional amendment. First tier at the district level, second tier at the block level, and this is the third tier, right? First tier, second tier and third tier at the village level. So here I have included, along with this rural areas, right, where you have these Panchayati Raj institution, here I have included these local urban local ULBs as well, urban local bodies that we are supposed to discuss into the next chapter. So if I talk about local self-government into the rural areas, right, at the top you have this district council or Jilla Parishad, whatever you want to call. Then at the block level you have this Taluka Samiti or Panchayat Samiti or Block Samiti, whatever again you want to call. Then at the village level you have this Panchayat, right, village council, whatever again. So first layer, second layer, or first tier, second tier, third tier. Further, the Panchayat for the purposes of election can be divided depending on the population that it has, right. Depending on that population, it will be divided into multiple wards. So this was about local self-government into the rural areas, means PRIs, Panchayati Raj institutions. So this was dealing with Panchayati Raj institution. In the cities, big cities, if I talk about, so the first tier is district council, same. The second tier, so difference will come at the second tier. This is the second tier you have, right. So at the second tier, different naming has been given to the different bodies, again depending on the population. So we'll discuss that what kind of population criteria is there. So depending on the population of the city can be awarded municipal corporation status, or it can be called municipalities, or it can be called Nagar Panchayat. The third layer will remain same, the third layer. So municipal corporation, again for the purposes of election. So third layer, here the third layer was Panchayat, but here and at the bottom you had this ward. See, to the wards into this PRI section, Panchayati Raj institutions, institutions, to this ward there is no constitutional recognition. Just for the purpose of election, this Panchayat has been divided. As far as constitutional recognition is concerned, constitutional recognition has been given only to these 3 layers. But here into the urban local bodies, ward has also been given constitutional recognition. So municipal corporation was the second layer, or the municipalities is the second layer, and Nagar Panchayat similarly is the second layer. So this is nothing, these are same thing, but just depending on the population of that particular city, right, different naming has been given. Again for the purpose of election, this municipal corporation can be divided into wards. So suppose the population of this municipalities is 9 lakh, right. So it can be divided into say 150 wards. So from 150 wards you will have councillor, and this councillor will finally get to elect chairpersons, right. Similarly with Nagar Panchayat. So this was all about structures. Now we are going to next slide to discuss the provision. So provision, as I already told you, has been divided into 2 parts, and the 2 parts is there are certain provision which are compulsory and there are certain provision which are voluntarily. So let us discuss what are these compulsory provision. As I already have clarified that the compulsory provision of 73rd constitutional amendment needs to be introduced into the Panchayati Raj acts of various states. There is no compromise at this front. Provisions which are compulsory of this 73rd constitutional amendment. At the front of these voluntary provisions, right, those voluntary provision is incumbent on the state. So it may vary from state to state. Certain few states may like to introduce these voluntary provision in their act as well. Few states may not like it, right. So let us see what kind of provision you have in this compulsory provision and what kind of provisions you do have in this voluntary provision. So these are 2 categories. The first category. So let us first discuss that what are the compulsory provisions of the act. 73rd Constitutional Amendment Act, right. So compulsory, that organization of Gram Sabha every state has to do, right. it is a compulsory provision. Then every state has to create 3-tiered structure. Every state has to create this state election commission, and every state has to create state finance commission. What is the purpose of creation of these state election commission? So see, state election commission is going to conduct the election to these municipalities and Panchayati Raj institution, because as far as election commission of India is concerned, it is responsible only for what you call election for this president, vice president, Rajya Sabha, Lok Sabha, legislative assembly and legislative council members, right? So for the municipalities and this PRIs, you had this creation of a state election commission and state finance commission, which will give recommendation that okay, what should be the principle governing the transfer of fund from the state to these bodies, then what amount of grant in aid should be given from the state to these bodies, right? So that kind of job will be done by state finance commission. At the union level as well, we have this constitution of union finance commission under article 280. We'll discuss that, right? So all the things that is done by finance commission under article 280 at the union level, similar function it will have. So earlier that union finance commission was dealing with the transfer of fund, or the principle that was supposed to govern the transfer of fund between union and state. Same function will be performed by state finance commission. It will actually recommend governor that okay, in what way and what amount of fund, right, should be transferred from state to these bodies, Panchayati Raj institution, urban local body. So that will be role of state finance commission. So this creation of state election commission and state finance commission has been put up under the compulsory provision. So every state will have to create these two bodies. Then all seats of panchayat shall be filled by elections, right? So you have 3-layered panchayat, right? At the district level panchayat, at the intermediate panchayat, and at the village level panchayat. So all the seats shall be filled by election except the chairmans. So you had this district level panchayat, you have intermediate level panchayat, right? I am not naming them right now, and you have this village level panchayat. So see, in all these 3 layers, you have 2 classes of people. One is you have these members, and another will, among these members you will have chairmen. So that will be at all these 3 levels, member and chairman, member and chairman, sorry, chairperson, right? Let's use a general neutral word, right? So chairperson and chairperson. So see, the chairperson at the intermediate level and chairperson at the top level, district level, they will be indirectly elected. See, none of the members, either be chairman or members, will be nominated. All people, all the members or all 3 layers will be elected. The matter of concern only is whether there will be indirect election or direct election. So see, members, as far as members are concerned, right, members at all these 3 layers will be, or all these 3 tiers will be elected directly by the people. So let us be clear, members, direct election. As far as chairman is concerned, right, so chairman at these 2 level, district level and intermediate level, chairman will be indirectly elected. Indirectly elected means what? So members will be elected directly and chairman will be elected amongst these members by these members, right, these members. So suppose at the block level 30 members has been elected. So chairperson will be elected by these 30 members amongst themselves. So one person out of these 30%, whosoever will get maximum number of vote, right, so he will be chairperson. Similarly at the district level, now the question arises that what will happen at this village panchayat level. So whether he will be directly elected or indirectly. See, in 73rd constitutional amendment itself, about the chairman at the district and intermediary level, it has been mentioned that they will be indirectly elected. But as far as chairman at the village level or the village panchayat level, it has been mentioned in this constitution that state legislature will decide whether the chairman at the village panchayat level will be directly elected by the people or indirectly elected by the elected member. So that power has been given to the state legislature. So let us read this point again. all of the seats in Panchayat should be filled by the election, indirect election for the post of chairperson at all three levels. So here the correction is needed. The correction would be that these two layers, indirect election, as far as this layer is concerned, at the bottommost means village panchayat level, state legislature does have power whether they want to go for the direct election or indirect election. Most of the state does have opted for indirect election for the post of chairperson at the village panchayat level. I'll hope you will have clarity on this point as well. So this point as well has been put up under the compulsory provision. Then reservation of for SC and ST brothers and sisters, right? So in proportion to the population, so suppose at one particular panchayat level, I am talking about village panchayat level. So in a particular village, the population is 10,000, and on those 10,000, 25 people or 25 ward councillor has to be elected, means that village has been divided into 25 wards. Now the population of SC and ST community is 4,000. Suppose STs are 1,000 and 3,000 is the population of STs, right? So 30% they form of this 20 and 10% of the population this ST people form, right? So 30% of this 25 seats will be reserved for SC community, and 10% of this 25 means almost 3 seats will be reserved for ST community. So reservation of SC and ST community in proportion to. So I have not written just all the words because that will make our notes bulky, that's why. So I am explaining you, right? So reservation of SC and ST community in proportion to their population, and this reservation will not be available only at the village panchayat level. This reservation will be available to all these communities, or whatever reservation in terms of women also will talk about. So this reservation is available to all the people at the village panchayat level as well, at the intermediate panchayat level as well, and at the district panchayat level as well. I hope that point you will have clarity on. Then 30%, 33% reservation, 1/3 of the seats should be reserved for the women. Again the same thing, that this reservation is available at all three layers. Minimum age for a person, now this is for if you want to contest a election. This is not if you are a voter. For a person to be voter, the age is 18. Right, that is available in legislative assembly election as well, and that is in Lok Sabha election as well. So this 21 year is for the candidate who want to contest the election. Next point, tenure should be 5 years, right? So that is again a compulsory provision. Now what is this 6 months? So this 6 months, so suppose village panchayat or intermediate level panchayat or a district council has been prematurely dissolved. So the term or tenure was 5 years. Now due to certain allegation that a particular village panchayat from last 2 years, so see accounts, whatever accounts that these people does have, that will be audited by independent agency. Now it was found during the audit that a particular village panchayat under the district panchayat has remained involved into the corruption. So on the charges of corruption, a village panchayat, whole of the village panchayat can be suspended. Now that will entirely depend on that a particular ward councillor has remained into the corruption or whole of the panchayat. If whole of the panchayat mistake was found, then that panchayat will be suspended or dissolved rather. So if a panchayat has been dissolved, so the tenure was 5 years, and now suppose 2 years down the line, after serving for 2 years, that panchayat was dissolved. So within 6 months, it will be the responsibility of State Election Commission and state legislature that within the 6 months of this dissolution, a new panchayat election should be conducted. So that is the meaning of 6 months. So these all provisions that we discussed under this column, these all provisions are compulsory provision. What are these voluntary provisions? So voluntary provisions are nothing. Let us see. Giving voting rights to MLAs and MPs in the meetings that they may participate. So at the most of the time at the district panchayat level, you have these MLAs and MPs. So suppose in a district, if I talk about say Gurugram, so Gurugram is a municipalities, municipal corporation it is. Now this municipal corporation has been divided into multiple wards. Just a moment, let me get into the previous slide. So here, so the Gurgaon Municipal Corporation. So this is district panchayat, their district panchayat or district council, whatever name they want to. Then you have this municipal corporation and this ward, right? So most of the time into the planning section at the district level, whenever there will be a meeting, whatever MLA. So suppose Gurgaon does have 6 MLAs, right, and 1 MP, member of parliament, right? So they generally do sit into the planning or into the meetings, planning meetings of these district council, because they have to settle, because ultimately see these, until this you have this involvement of MLAs, right, or the ruling party or the opposition MLAs, because ultimately these people know what level of resource state does have and what level of resources the parliament, because as far as see what is the job of district planning committees, right? So their plan is to prepare socio-economic development plan and send it to state planning committee or center as well. They can send that, hey, we need this level of grant, but now it is entirely on the state, because state also may not have that level of resources. So here it is case of competitive demand. So one district is demanding that we need 60 crores for our development. Another state may demand that, oh, this state has this district has demanded 60 crores, let me demand 100 crores, let me demand 200 crores. So there will be case of competitive demand. At the end of day, it is up to the state whether they do have that level of resources or not, and that's why involvement of MLAs and MPs as well become necessary, because it is these people who can guide these district, because these district does not have much of their own resource, right? They do generate their own resources as well from the levy of taxes and various other kind of fees, but they are also reliant on these states as well and union government as well. From there as well you have these cases of grant, right? So that's why involvement of these MLAs and MPs is necessary. Now whether the voting rights during the meeting when a resolution is taken up, these people are also present, these MLAs and MPs are also present. Now during the voting, if any resolution is taken up for voting, or if any policy is to be passed or any decision is to be voted or upon, right? So during that voting, whether these MPs and MLAs should be given voting rights or not, right, that provision has been put up in voluntary provisions, right? State legislature, if they want to extend these voting rights to the MLAs or MP or not, that has been put up in voluntary provision. So that is incumbent on the state whether they want to extend these rights to MLAs or not. Then financial autonomy to levy any kind of taxes, fee, whether they want to a particular state like Madhya Pradesh or Tamil Nadu, or they want their municipalities, their PRIs to levy, or and what all areas they want, or they want to allow these Panchayati Raj institution to levy tax and fees, right? So that option has also been put up in voluntary provision and not into the compulsory provision. Then this devolution of power to Panchayat body to perform functions that has been provided into the this 11th schedule. So as I already told you that this 11th schedule does have 29 items. So for the performance or whatever function that will be delegated or that will be devolved to these village panchayats, right, for the performance of that functions, right, certain amount of powers will be required. Now whether the state want to give that powers to these municipalities or PRIs, that will be incumbent on that state as well. Then reservation to the other backward caste, so that has also been put up under the voluntary provision, right? Reservation to SC, ST and women has been put up into the compulsory provision, but reservation to the OBCs, other backward castes, whether has to be extended at these 3 layers of Panchayati Raj institution, into the village panchayat, into the district panchayat and into this intermediate level panchayat, right? So that option has been put up into the voluntary provision, that has been put up in the goal of the state legislature whether they want to extend reservation to the other backward caste or not. So this was about the compulsory and voluntary provisions, right? So now I hope you will have clarity on the structure and the provisions of 73rd constitutional amendment. Now we are moving to discuss these articles, starting article 243A to article 243O. Now this article 243(a) talks about institution of Gram Sabha. What is this Gram Sabha? We already have talked about, so it is nothing but combination of all those people who are eligible voter from that particular village. Now the size of Gram Sabha, if I talk about, the size of Gram Sabha may vary from one state to another state depending on population. So it is completely incumbent on the state legislature that what size they are going to decide for a particular Gram Sabha, right? Gram Sabha consists of all the registered voters of that village. Then Gram Sabha may exercise such powers and perform such function as the state legislature may decide. So I hope you will have clarity. Size of Gram Sabha may vary from one state to state depending on the state legislature. So I hope this article 243(a) you will have clarity on. Now we are moving to the next sub article rather, right? 243(b). So 243(b) talks about the structure of Panchayat. So structure of Panchayat as well we already know. So structure of Panchayat, it is a three-tiered structure where you have Panchayat at the district level, you have Panchayat at the intermediate level, and you have Panchayat at the village level. So three-tiered structure we already know, right? So they shall be constituted, or there shall be constituted in every state Panchayat at village, intermediate and district level in accordance with the provisions of this part. This part means part 9, right? Notwithstanding anything in clause 1, clause 1 is this. So notwithstanding anything in clause, Panchayat at the intermediate level may not be constituted in a state where population is not exceeding 20 lakhs, right? So that provision also we have already talked when we were discussing this compulsory provisions, right? Compulsory provision of 73, so third constitutional amendment act, that state where the population is below this 20 lakh, right? There this three-tiered structure is not necessary, just two-tiered structure will suffice, one at the district level and another at the village level. This provision has attempted to bring uniformity, this three-tiered structure, because prior to this article 243(b) coming into the picture, coming into the constitution, you had different state having different kind of tier structure. So 243(b) talks about structures of the Panchayat. I hope you will have clarity on 243(b) as well. Now we are moving to 243(c). So 243(c) actually talks about composition of these Panchayats and the election or nomination, whatever, right? So all the seats in the Panchayat shall be filled by method of direct election, right? And when it is saying all, this all should be taken with a pinch of salt, because you have this position of chairpersons, and this provision we already have talked about, that chairpersons at the district level, chairpersons at the intermediate level and chairpersons at village level, right? So as far as chairpersons at this district and intermediate level is concerned, it is already pre-decided in 73rd Constitutional Amendment Act that they will be indirectly elected and elected amongst the member who has been elected at the district level as a member and who has been elected as member at the intermediate level. So there will be election at the intermediate level, there will be election at the district level for the election of members, and these members amongst themselves are going to elect one chairperson at the district and intermediate level. As far as at village level is concerned, whether village level chairperson will be directly elected or indirectly elected, so in that area autonomy has been, or liberty has been given to the states, that a state legislature, that they'll decide that their Panchayat chairperson at the village level will be decided or will be elected directly or indirectly as happened at the district and intermediate level. I hope that point also you will have clarity on. The chairperson of the Panchayat shall be elected in such a manner as state legislature may provide for. Chairpersons of intermediate level and district level should be elected amongst its member, right? So at the village Panchayat level, state legislature may decide, but at the intermediate level and at the district level it will be decided, it is already decided by the 73rd Constitutional Amendment Act that they will be indirectly elected. I hope you will have clarity on. State legislature may also provide for involvement of member of parliament and member of legislative area belonging to that area. So it can't happen that district council meeting is ongoing and you have MLA's involvement from another district. right, whose territorial area does not fall with this area, right. So that can't happen. So if a district council meeting is ongoing, then MLAs and MPs of that particular area can only participate, and that too if state legislature has made such an provision. A state legislature of different state can eliminate their role, but generally MLAs and MPs are allowed to participate in their meeting. However, whether they'll be having this voting right during that meeting or not, that will be decided by state legislature. So I hope this composition nomination article 243C as well you will have clarity on. There are certain other points as well into this composition and this election method. So at the district level, if I talk about the size of Jilla Parishad or the district council varies from 50 to 75. So minimum size will be 50 while the maximum size can be 75. And now what this Jilla Parishad or the district council consist of, what classes of people or what classes of member. So first they'll have an indirectly elected chairperson, right? Then elected members, there will be election, right, at the district level as well, at the intermediate level as well, and at the village panchayat as well, keeping in that reservation option in mind, right. Reservation we'll discuss in this other sub article, right. So there will be reservation at all these level. Members will be elected for the district, intermediate, village level. Then thereafter at the district and intermediate level, chairperson will be indirectly elected. Indirectly elected means what? They'll be elected amongst themselves, means members will sit together and one of the member out of many member, whosoever get majority of the voting, he will be elected as chairperson. Then chairpersons of the panchayat samitis as well. So district level, district council we are talking about. So district council will also consist of the chairmans of these. So under the district, let us try to understand your structure. So under the district there will be multiple panchayats at the intermediate level. So there can be 4, 5 or 10 depending on the population of this particular district. So there will be block panchayat at this tier 2. This block panchayat BP, let us refer it as BP, block panchayat or panchayat samiti or taluka samiti, whatever you want to. I am calling this block panchayat. So this block panchayat chairman, every block panchayat will have a chairman. So their chairman, right, they will form part of ex officio members, right, ex officio. So whosoever will be the chairman of this block panchayat, he'll automatically become member at the district level, right. So you have elected members first, right, and then these people, the chairman of this block panchayat also will form part of ex officio. They will also be part of as ex officio. So they will be participating in the district council meeting as well. Thereafter you have these MLAs and MP with or without voting rights as has been decided by the state legislature. On the administrative side, so this is about the elected side. So all the decisions will be taken by these elected people, that okay, what should be the policies, what should be during the planning, what should be the developmental plan, right, how much money we require, right. So how do this planning function work, so that we'll discuss in other articles. So the role of this district planning commission or this elected members is that they'll take ultimately all the decisions at the administrative side. So after taking, so they will have a, suppose in a month they will have 2 meeting or 3 meeting depending on the nature or depending on the culture of that particular district. So they may have 1 meeting in 2 months or they may have 2 meeting on 1 month. They will take some decision, and after that decision has been taken by these elected members. To implement those decisions, it will be job of administration, right. So administrative body at the district level will be headed by a IAS rank officer. He may district magistrate in some cases, he may district collector in some cases, right. So this IAS officer is going to head that administrative division at the district level, right. If at Gram Panchayat, if I talk about at Gram Panchayat level, you will have these ward councillor as elected members, and then from the state government, right, here at the district level you had this IAS officer. Similarly here you will have this secretary, Sachiv, right. So secretary will be there, who will be appointed by the state legislature. Again there is objection on this point as well, that these PRIs, Panchayati Raj institution should be given independence to appoint their own personals, because most of the time, whether be at district level or be at this Gram Panchayat or intermediate Panchayat level as well, right, this manpower for the administration is provided by the state legislature, and because this manpower has been provided by the state legislature, on their termination or taking any kind of disciplinary action, they have to get means if I as a sarpanch, if I do have certain grievances regarding this secretary, right, I cannot directly remove him. I can simply, when a meeting is ongoing at the district level, I can ask as a sarpanch, right, I will not remain present, so I will go to this Panchayat Samiti chairperson who is going to participate in the meetings of this district council, so he will complain to this IAS officer to change this secretary or to take any kind of disciplinary measure. So being a part of this Panchayati Raj institution, as a panch, as a ward councillor, as a sarpanch of any village, I do not have any power. So it has been recommended, when we will discuss the effectiveness of Panchayati Raj institution, you will see that there is debate on this particular topic as well, that if you have to truly empower these Panchayati Raj institution, there are three things that as a state legislature you will have to do. You will have to give them genuine taxation power, right, whatever taxation power so far has been extended even by the progressive states like Rajasthan, like Tamil Nadu or other southern states, those are just symbolic, right. If Panchayat, if at the city level, if I talk about, right, this Mumbai Municipal Corporation, whatever Bruhat Mumbai something it is called, or MCD, Municipal Corporation of Delhi, or Municipal Corporation of Faridabad, or Municipal Corporation of Gurgaon, right. So any municipal corporation or any Panchayati Raj institution, from finances point, if I talk about, right, their financial mobilization, whatever area that they have been given a power of taxation, from that taxation power they can hardly meet the salaries of their people, leave alone the development requirement of those cities, leave alone the sanitation requirement, leave alone these lightings that they are supposed to do in various streets, or leave alone these digging the canals or any development work that they are supposed to. What kind of the level of responsibility that they have been assigned by the state, at the similar level of taxation or levying of fee, that kind of power has not been given. Similarly, on these appointment of these functionaries is concerned, right, this is not in control of these Panchayati Raj institution or urban local government. When we will discuss the municipality, there as well we will highlight that point. So if to this Panchayati Raj institution, that is supposed to be third tier of the governance, right, you had this union, you have this state, and this is supposed, this was means at least this was envisioned in 73rd constitutional amendment in 1992, that this is going to get democracy at the grassroots level. You are going to, means this was a visioning, right. So this act is going to politically empower our women, our SC ST people, our these general people, right. So this is going to politically empower these people. This is going to, means we are taking governance closer to these people. But if you have to really, as a state legislature, as a union, if we have to truly harness the potential of these people, if we have to teach that how local governance is done, if we truly have to have them in this democracy, what we'll have to do is that we'll have to have genuine transfer of fund, genuine transfer of these functionaries, and the genuine transfer of functions, whatever functions as well. So we talked on the front of finances that there is no genuine transfer of finances. The level of responsibility that they have been assigned, to that tune finances has not been, or taxation power to that tune has not been given, right. So even now the finances that they generate, as I already pointed out, they can hardly meet up the salary of their personals, right. The personals that, so these IAS that has been appointed in major cities as a district collector or municipal commissioner or the secretary, so their salaries is paid by the funds of these people. So hardly they can meet their personal, or many of the sanitation or safai karmcharis that they have appointed, right. So their salaries they can hardly, so whatever their requirements, so suppose a budget of a particular municipality, municipal corporation of a smaller city for a year is 220 crore, they can hardly generate from the taxation 40% of this 220 crores. For the other requirement, for the other crores that they need, right, they have to completely rely on the grant in ads from the state government or grant in ads of these central government, or the grant in ads or some kind of donation from industrial association or other people, other influential people in that particular area, right. So that is the position of municipal corporation, or that is the position of Panchayati Raj institutions in our country. So that's why I was saying that if we have to truly harness, if we have to fulfill all the objectives of the local self-government that has been mentioned in 70, or that was the statement of object into the 73rd constitutional amendment, we'll have to have genuine transfer of funds, finances and functionaries. Coming back to this topic. So this topic, Gram Panchayat consists of indirectly or directly elected chairperson, ward member. So this you can simply mean this we already have discussed. So this was about this sub article 243C. 243 talks about the reservation of seats. So reservation, again we already have discussed when we were discussing these compulsory provisions. So there we had discussed that you have this provision of reservation for SC communities, ST communities and women. For SC and ST, it is in tune of it is in proportion to the population they have in a particular panchayat, right. So you will have reservation at all three levels depending on their population in that particular geography. As far as women are concerned, so for women we do have 1/3 of reservation at each level. If I talk about reservation for the chairpersons level as well, so there are certain state that has reserved the chairperson's post as well for SC and ST community on the basis of these rotation, right. So that point we already have clarified. So that point we are not discussing here because that has already been discussed. So I hope this 243D as well you will have clarity on. Now article 243E talks about the duration or the tenure of panchayat. So when I am saying panchayat, I am referring to all three levels, at the district level, at the intermediate level and at the village level, right. So tenure of panchayat was supposed to be or is supposed to be 5 years, right. It shall once elected, once a panchayat at the village level or panchayat at the block level or panchayat at the district level has been constituted, you have a body elected, then it should function for next 5 years. But if there is any circumstance, state legislature has been imparted. So if there is charges of corruption on a particular village panchayat or block panchayat, then that body can be dissolved by the state legislature. But state legislature has been instructed by the 73rd constitutional amendment. Again I will point out that we already had discussed in the compulsory provision that the tenure was supposed to be 5 years, but due to any compelling circumstances, if an elected body is being dissolved, in that case state legislature does have this obligation that they'll have to have next election within 6 months of that dissolution. If there has been a premature dissolution of a particular house due to any compelling circumstances, right, then state legislature will have to have election within 6 months. However, in one situation the state legislature has been given relaxation, and that one situation, so suppose only 6 months term of a particular panchayat was pending. So once that body was elected, 4.5 years or 4 months 8 months 4 years 8 months had already passed. They had governed for 4 years 8 months. Thereafter they indulged in some kind of activity due to which that body the village panchayat or block panchayat was dissolved. So now if the pending period or the remaining period is only for 4 months 6 or less than 6 months, then state legislature and election commission of that state is not obligated to conduct the election within 6 months. So that obligation they will not have in the case when the body has been dissolved 6 months prior to the next scheduled election. I'll hope that clarity you will have. So now suppose a body has been dissolved, suppose 2 years was pending or 3 years was pending for the previous body for the previous panchayat, and that was dissolved, right. Now the next body that will be elected, they will not serve for full 5 years. So if you remember, when a Lok Sabha is dissolved or when a legislative assembly is dissolved, then you will have new election, and in this new election, when you will have a new legislative assembly or when you have a new Lok Sabha, in that case the new Lok Sabha and new legislative assembly serve for full 5 years, right? But in this case, when a legislative assembly or when a panchayat, either at the village level or block level or district level, has been dissolved prematurely, suppose 3 years they had completed, 2 years was pending, and now this body is being dissolved, in that case the newly constituted this panchayat will serve only for 2 years and not for full 5 years. Now the question that you can ask is that why this discrimination? When you have this new legislative assembly, when you have this new Lok Sabha, after reconstitution or after newly elected Lok Sabha is in place, right, full 5 years in both the cases. So why this discrimination with the panchayat? So the reason being, see, this Lok Sabha and legislative assembly works independently, but as far as this village panchayat or blocks panchayat or taluka samiti is concerned, they do not work independently. They have to work with other panchayats as well. So let us try to understand. So if a structure of this panchayat you have in mind, right, we had discussed in the previous slide as well. Let me clear this. So you have this district panchayat or district council or jila parishad, whatever you want to call it. Under this district panchayat, you may have tens of block samiti, or at the intermediate level it can be taluka samiti. So let us call it taluka samiti, TS. So you have these 4 taluka samitis, and under every taluka samiti you may have 4 or 5, again depending on the population of that particular taluka samiti, you may have 4 or 5 village panchayat. Let us refer it as VP, village panchayat, village panchayat, village panchayat. So you may have 4, 10 or whatever depending on the population, right? So depending on population you have these village panchayat under every taluka samiti, right? Similarly under this as well. So suppose a particular village panchayat was found during the audit, it was found that a particular village panchayat was in corruption, indulged into corruption, and that was dissolved. Now the election will be held. Now see, election of all these bodies had been held at the same time. District council or taluka samiti, they had been elected, right? So now when a village panchayat is being re-elected, is being reconstituted after election, right, if the tenure of this village panchayat is kept 5 years, then they'll continue functioning even after their terms has end. And that's why I was saying that as far as these panchayats are concerned, they do not work independently. But that is not case with the legislative assembly, and that is not case with the Lok Sabha, right? They works independently, and that's why when Lok Sabha or legislative assembly is dissolved and you have a new legislative assembly or new Lok Sabha, right, they continue to function for next 5 years, full term they complete. But that is not the case with this reconstituted or newly constituted village panchayat or block panchayat, right? I hope on that point you will have clarity on. So this was this article 243. So you have this article 243F. 243F talks about disqualification of members, right? So you have this village panchayat, you have these 3 layers of panchayat, you have these elected members. Now on what grounds they'll be disqualified? So there are 2 grounds actually. The first ground, so for the grounds of disqualification of members of panchayat is same as the grounds of disqualification for member of legislative assembly. So if you remember, in the state legislature we had discussed this article 191. Under article 191 you have these grounds on which a member of legislative assembly can be disqualified, right? So on whatever grounds that has been mentioned for the disqualification of member of legislative assembly, right, on those grounds, if these members of panchayats are falling, right, if they are violating any of the law or any of the ground that has been mentioned in article 191, then these village panchayat members as well can be disqualified. So that is one ground. There is another ground as well, another set of ground can be carved out by the state legislature. So there are 2 type of ground. The one ground is that if a member has violated any ground that has been mentioned in Article 191, although in this Article 243F it has not been mentioned that under article, this mention of Article 191 is not there. The only thing that is mentioned in Article 243F that talks about disqualification of the members, right? If a member of Panchayat will stand disqualified if he is disqualified for being MLA. So that is means it does not talk about this Article 191, but you can deduce that because disqualification of MLA has been mentioned in Article 191 plus RPA, Representation of People Act 1951, right? That I was forgetting. So there are two grounds or two classes of ground on which these member of Legislative Assembly can be disqualified. The first is mentioned in article, that is Constitution, Article 191, and the second was in Act, right? This we have discussed extensively, right? And second set of qualification on which these members of Panchayat can be disqualified, the second set can be cited by or can be enacted by state legislature. So a state legislature is also empowered to cite any kind, to lay down any kind of grounds on which this village Panchayat can be disqualified. I hope this disqualification parameter you will have clarity on. Now this Article 243G. So Article 243G actually lays down the grounds or actually going to institutionalize the planning role of these panchayats, right? So until now all the socio-economic or developmental planning is being done by the state for their citizens or for their voters, right? Or for the public. So this state was doing, state means that particular state not mentioned in the part 3. When I am talking about state in this part, I am talking about these Madhya Pradesh, Maharashtra and these kind of states, right? So until now planning, all the socio-economic or development planning was being done. Until when I am saying, I am talking about the 73rd constitutional amendment which brought these PRIs, Panchayati Raj institutions. So until coming up of this 73rd constitutional amendment, you had this state which was bringing or which was coming up with the socio-economical or development planning, right? But after this 73rd constitutional amendment through which these PRIs came up, right, it was envisioned that some of the functions of the state can be delegated to these PRIs as well, Panchayati Raj institutions as well, or urban local bodies as well. Some innocuous functions, some easy functions that can be performed, for which these PRIs are capacitated, for which they can be given finances, right? Because ultimately it is these people who are closer to these people living in villages, and they know the requirements, they know, they do have better understanding of the requirements of these people residing in the villages. So functions like, when we'll discuss this 11th schedule, I'll let you know that what kind of functions like appointment of ASHA worker, functions like library, functions like entertainment, functions like what you call these agriculture, right, function like these irrigation. So those kind of functions, there is actually list of 29, animal husbandry, fishery, poultry, right? So these kind of development function can be delegated, rather not delegated. Delegated is something, means you will have to be very cautious about this word delegation. So difference between delegation and devolution, right? So devolution is actually constitutional transfer of power or function or authority from any institute or any entity to another entity, while delegation is not constitutional transfer. Delegation is simply that, hey, for time being, means I do not have resources, or I do not want to do that, right? Or I do not have that space, I do not have bandwidth in terms of time. So for time being you can do it, but as and when it will become inconvenient or convenient for me, I can take back those functions from, or the authority from you. So that is delegation, while the devolution is constitutional transfer. So constitutional transfer, if happens, right, that cannot be taken back by the transferring entity. So that is the meaning of, or that is the difference between delegation and devolution. Now what I was talking about, so I was talking about this Article 243G that is going to institutionalize the planning potential or planning power of the panchayats. Means it is going to transfer, or at least it is going to talk about that the state should transfer some of the function or some of the power or some of the authority to these Panchayati Raj institution in order to make them self-government, right? In order to, so what is the meaning of this? See, PRIs, Panchayati Raj institution, and urban local government, right? These are urban local government, ULBs. So these are collectively called local self government. Local self government. Local means limited to a particular geography. Self means they are talking about self rule, right? Self rule, same self rule or self government that Gandhi talked about, right? So local self government, but the spirit of local self government, as I had been discussing in the previous, cannot be truly materialized if you do not have a genuine transfer of authority, genuine transfer of power, genuine transfer of funds, genuine transfer of functionaries, right? So this article 243 is talking about finances. We'll talk about in H, right? And I will talk about State Finance Commission, but this is talking about at least the planning part. So let us read this article, sub-article rather. So legislature of a state may by law endow the panchayat with such powers and authority which may be necessary to enable them, you have to keep reading this, right? Which may be necessary to enable them to function as local self-government, right? I hope that you will have clarity on. Now, how they will be enabled to function as an institution of local self-government? Unless you do not transfer the power, unless you do not transfer the authority, unless you do not transfer the funds, right? They cannot function as an institution of self-government, right? How can be a self-government when they do not have money? Means, see, as soon you said that this is a power center, this body is going to be a power center, there will be requirement, there will be people coming from different domain that, hey, my street does have this problem, my society does have this problem, can you look into this form? So the requirement ultimately you will see that will come pouring on from various society, from various section, but as long as they do not have functionaries, right, they do not have people who are capacitated enough, right, to do that kind of work, unless they do not have finances, unless they do not have those resources, they cannot function as a local self-government, right? So article 243G, right, finances I talked about in this point itself, but finances we are going to talk in article 243H, that is next sub-article. So this is primarily talking about the planning power, planning function of this Gram Panchayat, right? Article 243G has institutionalized planning of the panchayat. District council generally prepares. So what is the role? It is talking about the role, and this was actually a sub-article. This is my explanation. So district council generally prepares the plan of socio-economic development, and आफ्टर डिस्ट्रिक्ट प्लानिंग काउंसिल और डिस्ट्रिक्ट काउंसिल कैसे सोशियो इकोनॉमिक डेवलपमेंट प्लान तैयार करता है, तो यू विल हैव प्लान्स फ्रॉम, प्लान का जो फ्लो होता है वो इस तरह से होता है कि ग्राम सभा अपनी रिक्वायरमेंट अगले 1 साल की ग्राम पंचायत को कम्युनिकेट करेगी, ग्राम पंचायत इन ग्राम सभा की सभी, सो सपोज देयर आर 3 ग्राम सभा अंडर 1 ग्राम पंचायत, तो तीनों की रिपोर्ट ग्राम पंचायत कोलेट करेगा, कुछ थोड़ा बहुत एलिमिनेशन करेगा बिकॉज ग्राम पंचायत को पता है कि भाई इतने फंड शायद डिस्ट्रिक्ट प्लानिंग कमीशन के पास ना हो, राइट। तो फाइनली ग्राम पंचायत थोड़े बहुत चेंजेस करके इस ड्राफ्ट प्लान को, एंड दिस इज नॉट फाइनल प्लान दैट ग्राम सभा और ग्राम पंचायत इज फॉरवर्डिंग, दीज आर जस्ट ड्राफ्ट प्लान्स, राइट। सो दिस ग्राम पंचायत विल सेंड इट टू पंचायत समिति, पंचायत समिति थोड़ा बहुत, बिकॉज पंचायत समिति अगेन विल हैव अंडर मिनी ग्राम पंचायत, सो थोड़ा बहुत ट्वीकिंग करेगा पंचायत समिति, एंड पंचायत समिति विल फॉरवर्ड दिस प्लान टू डिस्ट्रिक्ट काउंसिल और डिस्ट्रिक्ट प्लानिंग कमेटी और जिला परिषद, वट एवर यू वांट टू कॉल, ठीक है। और जिला परिषद जो है और डिस्ट्रिक्ट प्लानिंग कमेटी जो है, राइट, दे ओवरसी द प्लान्स फॉरवर्डेड बाय दीज, पंचायत समिति थोड़ा बहुत ट्वीकिंग करके ये स्टेट प्लानिंग कमीशन को, स्टेट प्लानिंग कमीशन को ये भेज देगा। सो दिस इज द प्लानिंग रोल ऑफ डिस्ट्रिक्ट प्लानिंग कमीशन और दीज बॉडीज, व्हाइल सेंडिंग सच प्लान आइदर टू स्टेट और प्लानिंग कमिटी और स्टेट गवर्नमेंट, इट मस्ट मेंशन फाइनेंशियल रिसोर्सेज अवेलेबल एट इट्स डिस्पोजल। सो व्हेन डिस्ट्रिक्ट काउंसिल, डिस्ट्रिक्ट प्लानिंग काउंसिल is sending these reports to the state government directly or state planning committee, right, so it needs to mention that what level of resources I am expecting to generate in 1 year, and what kind of grant in ads or what kind of transfer from consolidated fund of state I would require from your side, right. I hope that point you will have clarity on. So powers, authority and responsibility of panchayats, right? This article 243G is talking about. Let us discuss the next sub article, that is article 2 sub article 243H, right? So it is talking about the power of the taxation that is supposed to be transferred. So until tax is being imposed by, until when I am talking about this until 1992. So until 1992 these taxes were being imposed on various areas in state, either on citizen or their resources, right, by the state, right? But now it was expected that some of these taxing powers, some of those fee levying power will be transferred to these municipal bodies, urban local government or Panchayati Raj institution, so that whatever responsibility that we are transferring by the cash that they have generated from, by taxing the people, by taxing their property, by levying any kind of service fee, right? So municipal, if you have been living in the cities, right, you would be knowing that whatever water usage that we do, right, we pay certain amount of fee, right? If you are using any kind of other services, then again we do pay fee. Just a moment. So we do pay fee for that, right? So that kind of power this state will have to endow to this municipal corporation of Panchayati Raj institution if it in rural area. So that it is talking about article 243H, power to impose taxes and funds of the panchayat. So legislature of the state may by law authorize a panchayat to levy, collect and appropriate. Levy, tax लगाना, collect, उसको gather करना and appropriate, अपने पास रखना, right? So there may be, means until this arrival of GST, you had this classification various, we have not covered this center-state relation, otherwise when we would have entered into the financial domain or the financial power of this center-state relation, financial aspect, we would have discussed that taxes are divided into multiple parts. Sometime these states levy and collect, but it is given to the center. Sometime it will be levied by the center, but it will be given to the state. So that's why the difference between that who is levying the tax, who is collecting the tax, and tax is appropriated by which agency, right? So there is a difference, right? So the state legislature of the state, right, may by law, may by any act transfer or authorize panchayat or municipality. Similar will be language when we will discuss the municipality bodies. Rather, we will not discuss these kind of articles. So similar kind of power, or similar kind of function, or similar kind of election or composition that we have been discussing from last 20 minutes. Similar sub articles you will find in municipalities section as well, urban local bodies as well. So there we will skip these things, right? So here you do have panchayat, but that panchayat will be replaced by urban local bodies in the corresponding sub article when we will discuss the municipalities as well. So the legislature of the state may by law authorize a panchayat to levy, collect and appropriate such taxes, duty, toll and fees in accordance with such procedure and subject to such limit. Assign the sub clause of the sub article, assign to panchayat such taxes, duties and toll and fees levied and collected by the state. If state has collected any kind of taxes, duties and tolls, ठीक है, अगर स्टेट ने कलेक्ट किया है तो उसका भी कुछ जो शेयर है वो स्टेट ने म्यूनसिपैलिटीज को या पंचायती राज इंस्टीट्यूशंस को देना चाहिए, राइट? प्रोवाइड फॉर मेकिंग ग्रांट इन एड, अगर उससे भी काम नहीं चल रहा है देन सम काइंड ऑफ ग्रांट इन एड आल्सो स्टेट मस्ट provide, right? So this is talking about the financial power or the tax levying power that state should transfer from itself to these bodies, these Panchayati Raj institution or urban local bodies. I hope you will have clarity on this article 240, sub article rather 243H. Now article 243I is talking about institution of finance commission. So this institution of finance commission at the central level had been talked in article 280 rather, right, which talks about institution. So president every 5 years or earlier as well, right, can institute a finance commission. The role of finance commission we already know. So the governor, sorry, it is he governor, it should be the governor, right? So the governor of the state shall, as soon as may within 1 year, so 1 year it is talking about, so state finance commission is not being constituted from this operationalization of constitution, because State Finance Commission came into the picture only after institution of these Panchayati Raj institution and urban local bodies, right? That's why when you will see that how many number of time union has constituted State Finance Commission and how many times a state has constituted a State Finance Commission. So always state share in constitution of finance commission at the state level will be lesser. So hardly there will be 4-5 cases of constitution of State Finance Commission by any state, especially even those 4-5 cases will be only where in the state which has been continuously conducting the election every 5 years, right? Otherwise there are cases like Jharkhand which has not continuously, after this institution, means Jharkhand was established in 2002 if I am not wrong. So after the establishment of 2002, right, for 12 continuous years this state did not conduct election of Panchayati Raj institutions. So here the institution of State Finance Commission, SFC, will be even less, perhaps twice or thrice. I do not have number for this particular state as far as State Finance Commission institution is concerned, but I can say with the guarantee, because when you are not conducting election for 12 around years, right, how many, because every 5 years you have to constitute, so hardly 1 or 2 finance commission it would have instituted. I hope you have clarity on. So governor of the state, and what is the job of this State Finance Commission if I talk about, right? So the job of the state, job of the Finance Commission is to advise governor on what matters. So you have this State Consolidated Fund of India, and this State Consolidated Fund of India is full of money, right? It is taxing people, it is taking loan, it is generating other kind of revenue, it is receiving any kind of interest, right? So its exchequer is completely full. But here, and these images are only for the representation purpose, here you do have Panchayat or municipality treasurer and it is completely vacant, right? So the job of this finance commission that will be instituted by governor will be to advise governor in regards to what? In regards to the principle that will govern the transfer of funds from here to here, right? So state has to give some amount of, because in the municipal area as well this state is, so if this is the territorial area of a municipal corporation in the city or Panchayati Raj institution, right, in the villages, if this is the territorial area, in this area as well state is taxing the people on various ground. In the agriculture by the most of state has not been taxed, right? So on the revenue, on the stamp paper, on the other things, right, for the irrigation, state is taxing in the territorial area of this municipal corporation or PRIs as well, right? So if the state is collecting tax, so state should share that tax with the municipal corporation or the Panchayati Raj institutions as well. So what principle will govern this transfer of fund, right? That principle will be advised by State Finance Commission to the governor, right? And governor finally will cause this report or this principle to let down on the floor of the state legislature. So that is the first job that it is talking about, right? State Finance Commission. Second function of this what you call this State Finance Commission would be that how to suggest governor that how the funds or this treasure of Panchayati Raj institution and municipality can be augmented, right? What innovation, what kind of innovation or what kind of areas, right, where people are not being taxed, or what are the innovation that these municipalities or Panchayati Raj institutions should bring in their methodology of working or should bring in other areas that will augment their resources, right? So that is going to be the job of State Finance Commission, right? One difference between Union Finance Commission and State Finance Commission is that in this article 2, sub-article 243I that talks about institution of State Finance Commission, it does mention that every 5 years, while in article 280 that talks about institution of Union Finance Commission, that says every 5 years or earlier. So that is also a difference. I hope this article 243I you will have clarity on. Now we are moving to, okay, what is this slide? This is the additional slide, you need not to. Then article 243 talks about the audit of the account. So now municipal corporation bodies or PRIs does have some funds that has been given either by the center in form of grant in ad or by the state through transfer or by grant in ad, or the municipal corporation or PRIs have their own funds as well. So whether that fund, what is the meaning of audit? So audit, the meaning of audit is appraisal, right? Whatever funds that you do have at your disposal, whether those funds are being used or utilized in a right manner or not. Is there any case of misappropriation, misabuse, right? So audit can be, means this is not the scope of this video, but audit can be divided into, it can be legal audit, it can be social audit, right? So there can be different kind of panels of auditor, right? That may be recommended by state legislature, right? On a state legislature panel, there may be private audit as well from some private companies or some NGO as well, which are professional in this audit function, right? So they may audit the accounts of panchayat or municipalities, right? And that audit agency will be mentioned, or first will be approved by state legislature, then only that audit agency can audit the accounts of these PRIs or urban local bodies. I hope this J 243J you will have clarity on. What about this article, sub article 243K? So article 243K talks about institution of state election commission. Again, this institution of state election commission we already have talked about when we were discussing this compulsory provisions, right? So there we had talked about that there were two constitutional agencies that is to be instituted, and that will lie into the compulsory provisions of the 73rd constitutional amendment, right? So here you have this this article 2 or sub article 243K talking about institution of this agency called State Election Commission. This will be a one member body, and it will have a state election commissioner who will be appointed by governor, although he cannot be removed by governor, because in state election commission it has been act, right, it has been mentioned that he will be removed by the procedure as by the high court judge, right? So high court judge is removed by the parliament on the by the president on the recommendation of parliament, right? So similarly state election commission, so state election commission is being appointed by the governor, but his condition of service and tenure is being decided by the state legislature, right? So appointment by governor, tenure and service condition by state legislature, and removal by president. Now this sub article, article 243L. Oh, L is missing, article 243. So article 243L talks about applicability of 73 third constitutional amendment to the union territory. So L perhaps is missing. I'll try to insert that article 243. So as of now, just remember that this article 243L talks about applicability of 73rd constitutional amendment act, right? Applicability of the structure, applicability of the provision of 73rd constitutional amendment to the union territories. Union territories like Chandigarh, Delhi, Puducherry, right? So all these areas. So whether that will be applicable to these union territory or with applicable with some kind of modification, that it is talking about, right? So let us discuss this article, sub article 243M. Now there are certain areas where this 73rd constitutional amendment or the Panchayati Raj institution, right, does not apply or apply with some kind of modification, right? So you have this 5th schedule area, 5th schedule and 6th schedule, what it is, right? We'll discuss when we'll discuss part next chapters, right? So that is pending. So as of now, just conclusion, you have to remember that there are 5th schedule area in which this 73rd constitutional amendment does not apply directly. It does apply, but with certain modification. So when we'll discuss this PESA, Panchayat Extension Services, right? So that there we'll discuss that how 73rd constitutional amendment does apply into the 5th constitutional 5th schedule area, but with certain amendments. So in the prelim, if there is a question that whether the provisions of the 73rd constitutional amendment apply to this schedule and tribal area, your answer would be no. But if it is saying that it does apply with certain modification, then yes, because that certain modification is nothing but that is PESA, P-E-S-A, that we'll discuss in this chapter, not in this video, but in this chapter we'll discuss. So nothing in this article or sub article shall apply to the schedule and tribal area. So it is talking about that 5th schedule. Second sub clause of this sub clause is that nothing in this part shall apply to the Nagaland, Meghalaya and Mizoram, right? Then hill areas of Manipur. So why these states has been given exceptions? So these exception has been given because these areas are tribal dominated area, and if you remember when we were discussing this article 371, that was special provision that has been given to some state, right? So these states were lying in that area. Not all the state. Meghalaya was not part under this article 371, neither Tripura, if you remember, right? So when we were discussing this article 371, you would remember that there were some hill area council or tribal council that were instituted for the governance of these areas, right? Keeping in their sensitivities, keeping in their indigenous culture, keeping in their custom, their laws, right, in mind. And that's why these areas, because they already have that kind of concession, they are already running their government on the self-government line, and that's why this concession has been given to these three states, Nagaland, Meghalaya, Mizoram, and then hill area, because hill area as of the Manipur as well, right? So hill area of Manipur, for which district council already exists, because again I am repeating myself that these states or these areas of this state, in West Bengal as well, you have this Darjeeling area where you have this district council, right, which is running their own self-rule, almost their own self-rule, and that's why they have been given concession. They have been given concession from applicability of 73rd Constitutional Amendment Act. So this was about Article 243M, right? For the prelim, you need to remember these states and these area: Nagaland, Meghalaya, Mizoram, then hill area of Manipur and hill area of West Bengal, that is in Darjeeling portion, right? So these 5 points or these 5 reasons you need to remember, that which are all exempted area. So along with this schedule and tribal area, that is 5th schedule area, although again in the 5th schedule area this act apply but with certain modification, right? The caveat I already have. As far as these states are concerned, or the portion of these states are concerned, you will have to keep these things in mind, right? So this was about the areas which has been given exemption from the applicability of 73rd Constitutional Amendment, right? Then Article 243N or sub Article 243N talks about the pre-existing. So prior to 1992 as well, you had these Panchayati Raj Acts in various states, right? So what will happen? What will be the status of these Panchayati Raj Acts in different state after the institutionalization or after the commencement of, so this act, Panchayati Raj Act, right, 1992 or 73rd Constitutional Amendment Act 1992 became operational on 24th April 1993, right? So what will happen? What will be the status of these acts, right? So that has been after the operationalization of 73rd Constitutional Amendment. So that has been talked in sub article 243N, right? So that will remain in operation. These acts, separate acts of different state, will remain in operation unless 2 conditions. Until first year, means on 24th this came operational. So these states act will remain in operation either until next 1 year, 24th April 1994, or until the state governments repeal this act. So maybe that state government may repeal it prior to 1 year as well, right? So if prior to 1 year, if the state government decides to repeal, then it will be repealed, or if state government does not do anything, then 1 year after this, 1 year after operationalization of 73rd Constitutional Amendment, it will be automatically repealed, right? This act will be automatically repealed. So this 243(9)(n) sub-article talks about applicability of state-specific Panchayati Raj acts which was in existence prior to 1990. What will be their position? So I hope this sub-article as well you will have clarity on. Now you have this last sub-article, that is sub-article 243 O that talks about election controversy. So what will be means if a candidate or winning candidate has been, if a candidate has been chosen as winner, right, and if there is any election controversy that he has indulged in any kind of election offences or any kind of malpractice, and if there is complaint, then which body, whether State Election Commission or Election Commission of India or governor, which body is going to adjudicate on that matter. So in that case, this 73rd constitutional amendment position is that authority, which authority will entertain such kind of cases, that will be decided by legislature of that state. That state legislature will be deciding authority whether that kind of case should go to the High Court, or that kind of case will go to governor, or that will go to the State Election Commission. So who is going to decide, right? That will entirely depend on a law, and that law will be designed by none other than legislature of that state. So with this sub articles, right, we are wrapping up this lecture with the 3 MCQs. So here you have this first MCQ, second MCQ, and the third MCQ. So with these 3 MCQs, I am leaving you. Till then, bye.